All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated, veuillez vous asseoir.
Good morning, everyone, parties, participants, and Mr. Said, good morning. I introduce the chamber. To my right is Judge Antoine Kesia-Mbe Mindua. To my left, Judge Tomoko Akane. I'm Rosario Salvatore Aitala, the presiding judge. Court officer, would you please call the case?
Good morning, Mr. President, Your Honors. This is the second situation in the Central African Republic in the case of the prosecutor versus Mahamat Said Abdel Kani, case reference ICC 0114-0121, and for the record, we're in open session.
Thank you very much. I remind everybody that you should speak slowly in order to allow the interpreters to do their job. Now, before we start the hearing on the confirmation of charges, the Chamber will address the request submitted by the defense on 11 October yesterday, 2021. But before this, I will ask the parties to introduce themselves, starting with the prosecution. Mr. Prosecutor, would you please introduce yourself and your colleagues?
Good morning, Mr. President, Your Honours. My name is Kareem Ahmed Khan. I'm the prosecutor. I'm joined today by Mr. Eric MacDonald, Senior Trial Attorney, Ms. Leonie Van Broon, Trial Lawyer, and Ms. Ramu Biteu, who's the case manager of the case.
Good morning. Thank you very much. Madam Counsel for the Defense, would you please introduce yourself and your colleagues?
Merci, Monsieur le Président.
Thank you, Mr. President. Next to me, Mr. Jacobs. Behind me, François Jacquemin, and our case manager, Victoria Aman-Lezien. I am Jennifer Nauri, lead counsel for Mr. Said. Thank you, Mr. President. Thank you very much, Counsel.
PCV, please. Would you please introduce yourself and your colleague?
Merci, Monsieur le Président.
Thank you, Mr. President. My name is Sarah Belay, counsel at the OPCV. And next to me, Caroline Walter, jurist for the OPCV. Thank you.
So as I was mentioning, the Chamber will first address the request of the defense filed yesterday, 11 October 2021, to be granted leave to appeal the decision on the defense request for postponement of the confirmation hearing. For the records, it is document number 201. I will now give the floor to the prosecution and the OPCV if they wish to respond to the request orally and shortly. Please, Mr. Prosecutor.
With your leave, Mr. President, Mr. Eric MacDonald will respond for the prosecution.
Mr. MacDonald, the floor is yours.
Thank you very much, Mr. Prosecutor, Your Honors. I'll be delivering my response in English because these are legal matters. And I shall be brief and to the point. The defense application for leave to appeal we submit should be rejected. The two issues the defense raises either misrepresent your decision or simply they're in disagreement with it. Accordingly, the defense fails to demonstrate the existence of an appealable issue genuinely arising from the decision. Now, for these reasons alone, Your Honors, the defense application should be rejected. Since the purported issues do not arise from the decision, the prosecution sees no need to address the remaining aspects pursuant to Article 81.2. I will address briefly the two issues raised by the defense. The first issue can be summarized as follows. The defense argues at paragraph 31 of their application that the chamber has not provided any reasons when it underlined, and I quote, that a postponement of the confirmation hearing is a serious measure that may only be taken on an exceptional basis in light of its important implications on the competing interest of the parties to the proceedings. End of quote. The defense first issue misrepresents the decision, and therefore it does not genuinely arise from it. Why? Because the chamber did explain how it came to its conclusion not to postpone the confirmation hearing and extensively address the defense's submissions and arguments. The chamber referenced the competing interest of the parties. The chamber's reference to the competing interest of the parties was only one of the many reasons the chamber gave when it rejected the defense's request. Furthermore, both the prosecution and the defense have an interest in expeditious proceedings, and the chamber's reference is clearly on its face, especially since the prosecution opposed the defense's request to postpone the confirmation hearing. So you clearly addressed that issue, Your Honors. I don't need to repeat all the reasons when discussing the issue of the competing interests. I will now move to the second issue. As stated earlier, this issue also misrepresents the decision and does not genuinely arise from it. The second issue can be roughly translated as follows at page 12 of the application. Did the pre-trial chamber guarantee in the contested decision the right of the defense to have the time necessary for the preparation of its defense, a right enshrined in Article 67.1 of the Rome Statute? Now, Your Honors, under this issue, the defense further argues at page 13 and 14 of its application that the chamber did not take into consideration, first, the circumstances of the case when it rejected the application, and two, the chamber did not address the obligation or necessity for the defense to analyze the totality of the prosecution's evidence in order to prepare itself for the confirmation hearing. Contrary to the defense's arguments, the chamber did indeed take into account the circumstances of the case. You extensively addressed the various circumstances, including the defense's submissions and arguments. Furthermore, and contrary to the defense's submission, the chamber did specifically address at paragraph 21 of the decision the defense's arguments that it needed more time to analyze all the elements disclosed by the prosecution. Mr. President, Your Honors, we respectfully submit that the defense's mere disagreement with the chamber's conclusion does not constitute an issue for interlocutory appeal. Therefore, the defense's application should be rejected. Thank you. This concludes our response. Sorry.
Thank you, Mr. MacDonald, Mr. Prosecutor. Madam Counsel for PCV, will you please make your submissions if you have any?
Merci, Monsieur le Président.
President, it is our desire to proceed quickly, and we simply want to say on this point that we agree with the submissions made by the prosecutor. The two questions raised by the defense, in our opinion, is simply a disagreement with what the Chamber's decision is with regard to the rejection of the appeal for deference of the confirmation of charges hearing. That is why that request should simply be thrown out. As far as we are concerned, we have the opportunity to express the views and concerns of the victims, and in that regard, I would like to say that the victims call for a rapid holding of the confirmation of charges hearings in order to obtain explanations as to the various questions that they raise concerning the crimes that they were subjected to. I also want to underscore that the rights to an expeditious trial, contrary to the assertions and thoughts of the defense, it's not a right that pertains mostly to the accused. At paragraph 11, it implies that this is a matter of legal principle and the constant jurisprudence of this court, whereby all parties and participants are concerned by the application of the law, particularly the victims who are participating in the proceedings and who expect an outcome to the crimes that they were subjected to 8 years ago. Thank you, Mr. President.
Thank you, Madam Counsel. What we will do now, I will adjourn the hearing for approximately half an hour. So we'll see you back in more or less at 10:15 in the courtroom. Thank you very much.
All rise, veuillez vous lever. Please be seated, veuillez vous asseoir.
Welcome back. Now the Chamber will render its decision on the defense request for leave to appeal, the decision on the defense request for postponement of the confirmation hearings, document number 201. The Chamber notes Article 82(1)(d) of the Rome Statutes. The defense request raises two issues. The first, the defense submits that the decision lacks reasoning in respect of the Chamber's finding that the competing interest of the parties to the proceedings must be considered in deciding whether the postponement of the confirmation hearing is warranted. Secondly, the defense submits that the decision fails to take into consideration the particular circumstances of the case and the arguments of the defense on the necessity to analyze all items of evidence disclosed by the prosecution. The Chamber also notes the oral submissions of the Office of the Prosecutor and of the Office of Public Counsel for Victims on the request of the defense. The Chamber decides that the issues raised by the defense do not arise from the decision and are not appealable under Article 82(1)(d) of the Rome Statute. With reference to the first issue, the Chamber considers that the defense misrepresents the Chamber's decision, which has addressed the defense submissions thoroughly. With reference to the second issue, the Chamber notes that the defense misrepresents again the decision and expresses a mere disagreement with the Chamber. The Chamber, in its decision, has indeed already taken into account all the circumstances of the matter and has taken multiple measures to address the need of the defense for adequate time. The issue is therefore not appealable. Both issues there are regarded as not appealable, and having said that, the Chamber notes that there is no need to address the other conditions under Article 81(1)(d). For these reasons, the Chamber rejects the defense request in its entirety, and we will continue with the hearing as programmed. Thank you. Now, turning to the matter of today's hearings, which is the confirmation of the charges brought by the Office of the Prosecutor against Mr. Said. It is my duty to recall that at this stage, the Chamber will not decide on the guilt or innocence of the suspect. Pursuant to Article 61(7) of the Rome Statute, our duty consists in determining whether there exists sufficient evidence to establish substantial grounds to believe that Mr. Said has committed the crimes with which he has been charged. The following general principles apply to this hearing. First, in accordance with Article 66 of the Rome Statute, the suspect shall be presumed innocent until proven guilty before the court. Second, the burden of the proof rests with the Office of the Prosecutor, who, as a result, will have to provide sufficient evidence in order to prove the charges brought against Mr. Said to the relevant standard I've just mentioned pursuant to Article 61, paragraph 7 of the statute. Third, the defense will benefit of all rights enshrined in Article 61(6) and 67 of the Rome Statute. I will also recall that the general rule is that this hearing is public and therefore it will be held in open session. It might occur that with a view to protecting private or confidential information, particularly regarding victims and witnesses, parts of the hearing will be held in private or closed session depending on the decision of the presidency of the Chamber. Pursuant to the order set in the schedule for the confirmation of charges hearing, filing 172 of 14 September 2021, the parties and participants shall have 20 minutes each for the opening statements. Then they will have 1.5 hours to present their observations under Rule 111 of the Rules of Procedure and Evidence, as well as their response detail. The prosecution is granted 1.5 hours and the defense 3.5 hours to present their respective arguments on the merits. The Office of the Public Counsel for Victims is granted 1 hour to present its arguments on the merits. The parties at the end and the participants will have each 30 minutes for the closing arguments. Now, I will remind that parties and participants' submissions should be concise in nature. Repetitions must be avoided. In particular, it is recalled that Rule 111 observations constitute an opportunity for raising issues or objections that were not previously brought to the Chamber's attention, and the parties and participants shall therefore refrain from repeating or reformulating previous submissions. Second, closing statements may not be used to raise new arguments, but only to respond to arguments and questions raised during the hearing. Technically, I recall that whenever parties and participants refer to evidence, they must indicate its level of confidentiality and specify whether it is necessary to move into private or closed session. Also, when in public session, parties and participants shall refrain from mentioning the names of victims and witnesses and rather refer to their respective codes and pseudonyms. Now, pursuant to Rule 111, Paragraph 1 of the Rules of Procedure and Evidence, I ask the court officer to read out the charges as presented by the prosecution in an abridged version of the document containing the charges. I recall that the defense has waived its right for the entire document to be read, but I also, speaking to the public, recall that the full version of such document is publicly available and provides better details about the charges. Now, please, court officer, would you please read the charges in the abridged version provided by the prosecutor? Thank you.
Thank you, Your Honor. The summary of the charged crimes. The prosecutor brings 14 charges against Mr. Mahamat Said Abdel Kani in relation to 2 detention sites in Bangui, the capital city of the Central African Republic. 1. Charges 1 to 7 concern crimes at a detention site known as the Office Central de Répression du Banditisme, or OCRB for short, from at least 12 April 2013 until 30th August 2013, relating to persons perceived to be supporters of Francois Bozizé, the former president of the Central African Republic. 2. Charges 8 to 14 concern crimes relating to acts at a detention site known as the Comité Extraordinaire pour la Défense des Acquis Démocratiques, or CEDAD for short, between mid-September 2013 and 8 November 2013. The crimes charged are the following. Crimes committed at the OCRB from at least 12 April 2013 until 30th August 2013, counts 1 to 7. Count 1. Imprisonment or other severe deprivation of physical liberty as a crime against humanity at the OCRB of persons perceived to be Bozizé supporters between 12 April 2013 and 30th August 2013, punishable under Article 7(1)(e). 2. Torture as a crime against humanity at the OCRB of persons perceived to be Bozizé supporters, including at least 16 persons who were tied using the abattoir method, and other persons who were severely mistreated in other ways between 12 April 2013 until on or about 30th August 2013, punishable under Article 7(1)(f). 3. Torture as a war crime at the OCRB of persons perceived to be Bozizé supporters, including at least 16 persons who were tied using the abattoir method, and other persons who were severely mistreated in other ways between 12 April 2013 until on or about 30th August 2013, punishable under Article 82C 1 to 4. 4. Cruel treatment as a war crime at the OCRB of persons perceived to be Bouzizi supporters, including at least 16 persons who were tied using the abattoir method, and other persons who were severely mistreated in other ways and detained under dire conditions between 12 April 2013 until on or about 30th August 2013, punishable under Article 82C 1 to 3. 5. Other inhumane acts as a crime against humanity of persons perceived to be Bouzizi supporters who were detained in deplorable conditions at the OCRB and who were verbally and physically abused, including during interrogations from on or about 12 April 2013 until on or about 30th August 2013, punishable under Article 7(1)(k). 6. Outrages upon personal dignity as a war crime of persons perceived to be Bouzizi supporters who were detained in deplorable conditions at the OCRB and or were tied using the abattoir method and or were verbally and physically abused from on or about 12 April 2013 until on or about 30th August 2013, punishable under Article 82C 2. 7. Persecution as a crime against humanity on political, ethnic, religious, and or gender grounds concerning the persons detained at the OCRB based on the facts underlying counts 1 to 6, punishable under Article 7(1)(h). Crimes committed at the Sedad compound between mid-September 2013 and 8 November 2013, counts 8 to 14. Count 8. Imprisonment as a crime against humanity of at least 33 persons at the Sedad compound between mid-September 2013 and 8 November 2013, punishable under Article 7(1)(e). 9. Torture as a crime against humanity at the Sedad compound insofar as several men were handcuffed to each other for several weeks, were hooded for prolonged periods, including by adding pepper powder into their hoods, were bitten until they passed out or submerged underwater to simulate drowning, or tied using the abattoir method, as well as other acts of comparable severity between mid-September 2013 and 8 November 2013, punishable under Article 7(1)(f). 10. Torture as a war crime at the Sedad compound in relation to the same acts just described for count 9 between mid-September 2013 and 8 November 2013, punishable under Article 82C 1 to 4. 11. Cruel treatment as a war crime at the Sedad compound, also in relation to the acts described for count 9 between mid-September 2013 and 8 November 2013, punishable under Article 82C 1 to 3. 12. Other inhumane acts as a crime against humanity insofar as at least 33 persons were detained at the Sedad compound in deplorable conditions between mid-September 2013 and 8 November 2013, and the Seleka at the Sedad compound refused to acknowledge their arrest, detention, and abduction, or to give information on their fate or whereabouts to their family members, punishable under Article 7(1)(k). 13. Outrages upon personal dignity as a war crime of at least 33 persons who were detained in deplorable conditions at the Sadat compound and or were tied using the abattoir method and or were beaten or verbally and physically abused between mid-September 2013 and 8 November 2013, punishable under Article 8(2)(c)(2). 14. Persecution as a crime against humanity on political, ethnic, religious, and or gender grounds carried out against at least 33 persons detained at Sadat based on the facts underlying counts 8 to 13, punishable under Article 7(1)(h). Thank you, Mr. President.
Thank you very much, Mr. Court Officer. Now, as I mentioned, the parties will have 20 minutes each. We start with the Office of the Prosecutor. Mr. Prosecutor, the floor is yours for 20 minutes.
Mr. President, Your Honours, it's a real privilege to address you and address this chamber for the first time as prosecutor. One must start, of course, with recalling the resilience, the courage, and indeed the patience of the survivors, the witnesses, and the victims who have courageously come forward to the office to give very difficult accounts upon which we rely to support this case and commend it to go to trial. The fact that we are here today should not be taken as a given. The last few months of 2019, the investigations being conducted by the office were suspended because of want of resources. Then, of course, the investigations and the work was affected, like the rest of the world, by the worldwide pandemic that continues to today. But the fact we are here today is a result of partnerships, that enough good people, enough people desirous of telling the truth, have banded together to ensure that allegations can be subjected to due process and to be determined by independent and impartial judges. That's the beauty of this system and this court in whose premises I have the honour to stand. Significant thanks must be given to not just survivors and victims, they're in the first category, but also to international organizations, NGOs, and I think it's right to say first and foremost to the national authorities of the Central African Republic. It was a desire for accountability that led the Central African Republic to refer this situation to the court back on the 30th of May 2014. And Your Honour, with greatest of respect, a great deal of credit goes to Your Honour and this pre-trial chamber, that in the less than 10 months since Mr. Said was arrested, a very well-structured set of proceedings have been put in place to allow, consistent with the presumption of innocence, the allegations that I put before this court to be properly scrutinized. Your Honour, Mr. Mahamat Said Abdel Kani, of course, is 51 years of age. We've heard the charges that have been read out against him. And Your Honours, all three of you are very familiar with the agony that was the Central African Republic from 2012 onwards. For those who are not, perhaps I can be permitted to very briefly state what is well known. That President Bouzizi, after almost 1 decade in power, was ousted by the Seleka armed group, which was an amalgam of different factions that came together for that purpose. And the Seleka, mostly Muslims, targeted those that were perceived to be supporters of former President Bouazizi. And they viewed these individuals as perceived supporters on account of various interlacing characteristics. Particularly, the evidence shows those that were Christians, those that resided in certain parts of Bangui, those that worked in certain professions, those that had been employed by the previous government of President Bouazizi, and also in terms of detentions. The evidence overwhelmingly shows that predominantly men were targeted. These combined intersecting reasons found the charge of persecution contrary to Article 7 1H of the Rome Statute, namely persecution on political, ethnic, religious, and gender grounds. But, Mr. President, Your Honours, it was this mistreatment that the Seleka were inflicting, these crimes that we say occurred, that also galvanized the community to create their own structures to defend themselves against those attacks. And in tandem with that, the former forces and elements and supporters of former President Bouazizi reorganized themselves from the DRC and from Cameroon, and then they joined together in inflicting pain and misery on the people of the Central African Republic. Currently, as Your Honours know, before Trial Chamber 5, in the Yakatom and Agasona case, the allegations in relation to what was called the anti-Balaka movement are under consideration. Unfortunately for the people of the Central African Republic, they were also not spared by the Seleka, and this case is but one snapshot, one still picture of a course of criminality that requires review by this chamber. Mr. President, Your Honours, in my respectful submission, and Your Honours will decide in due course, this is as straightforward a case as is likely to come before this court. This is not a case where Your Honours are going to be challenged to look at complicated theories of liability of a military commander or a civilian superior removed from the theatre of conflict. It is a detention case. And we say the evidence overwhelmingly shows that Mr. Said was in the room where it happened. He encouraged it, he facilitated it, but he also took part in beatings and mistreatment that justifies the forms of participation that are put in the document containing charges. People were put in just appalling conditions with no regard for their humanity. Your Honour, the conduct charged is, of course, alleged to be in the course of an armed conflict, not of an international character. And we say Mr. Said knew that his fellow citizens were targeted simply because they were viewed as perceived Bouazizi supporters. That was the singular reason why their humanity was disregarded and their rights violated. He knew that his own conduct was in the context of this armed conflict, and it was in that context that people were being raped, people were being killed, and persecuted for that reason. Now, one has to be clear. Mr. Said is not being charged for those murders, for those rapes that are part of the underlying evidence in this case. But it is my respectful submission that he cannot, on any view, plead ignorance. It is important to note that from the evidence in support of these charges, at the time he was overseeing the OCRB, the world was already aware of the rapes taking place. The groans from OCRB and the plaintive cries that are mentioned in the evidence had reached all the way to Geneva and international organizations. An example, perhaps just two, may suffice for the moment. In CIR OTP 2001-1759 at page 1764, Human Rights Watch reports that in May 2013, rapes were alleged to have been committed in Bangui. At the time, Mr. Said is said to have been actively involved in abducting people and interrogating people and helping in the running of the Sedad detention facility. The officer of the High Commissioner for Human Rights in Geneva on the 12th of September 2013, in their report, The Situation of Human Rights in the CAR, noted that people were being raped as perceived Bouazizi supporters in Bangui. They quote 7 women being raped in one incident. From another source, 4 women were raped. And in another variety of sources, they mention a 12-year-old girl was raped. Mr. Eric MacDonald will, in due course, and with the leave of the court, flesh out the evidence or highlight evidence that we say is of particular relevance to your Honour's pending determination. But one thing is clear. In relation to the attacks in April 2013 and August 2013 at Boirabe, the evidence discloses that Mr. Said was present. This was not a well-kept secret. The crimes, the scale, the link to the conflict, and the discriminatory intent was open to everybody, and unfortunately particularly keenly felt by the civilians in the CAR. Mr. President, the OCRB itself was a catalogue of misery. The charges themselves form of odious torture and mistreatment signals the wanton disregard for the sanctity of human life that every individual, regardless of race or religion or ethnic origin, has by virtue of their humanity. And that is the abattoir method of mistreatment. Your Honour, I'm not intending to refer to any confidential information in this hearing, and I would ask perhaps if Your Honours could press evidence 2, and a photograph can be displayed which speaks volumes. This is a survivor, somebody who by the grace and mercy of the Almighty lived to tell the tale. And the wounds one sees on his arms and shoulder, it's P547, are as a result of this abattoir mistreatment, where hands are tied together with ankles and elbows to contort the human body from its natural pose into an extremely painful, debilitating form of cruelty. It was not a restraint. It was deliberately done. Your Honour, so painful was it for P547 that at paragraph 59 of his statement, he states he was so bad, the pain was so excruciating, he asked his tormentors to put him out of his misery and kill him. In relation to the conditions, another photograph speaks far more eloquently than I could ever hope to do. Your Honour will see on the screen two pictures. The hole below is the location where many of those unfortunate souls were placed in terrible conditions without toilet, food, or any type of care. Literally standing above them was Mr. Said. We say that room and that area was his office. The evidence discloses that. He used to frequent it. And perhaps it's quite apt that literally standing on their heads, trampling on their dignity, stamping on their rights, he cannot plead ignorance. The smell was awful. The proximity could not have been closer. This is the type of criminality that gave rise to the charges before your honours. When, by the end of August, he was moved from OCRB, his superior, Nuruddin Adam, appointed him to the SEDAD. And this was a facility of the intelligence services of the CAR, which was turned with the assistance, connivance, and actions of Mr. Said to an unofficial detention center. And again, the same type of treatment of arbacha, of beatings or floggings continued. And all of that is in the file. Your Honour's relatives were never informed where their loved ones were. They went missing sometimes for weeks. They didn't know. Some thought they had died, but that agony, that trauma that was inflicted by being held incommunicado is captured in the charge of other inhumane acts. Your Honour, upon commencing my term as prosecutor, I instructed all the senior trial attorneys in the case to certify whether or not their cases gave rise to a realistic prospect of conviction. Mr. Eric MacDonald has so certified. For today's hearing, we say that manifestly the confirmation standard is met. With your leave, the last word, of course, must go to the victims and survivors who've been waiting for these years for some form, some modicum of justice and accountability. I have them, Mr. President, Your Honours, perhaps as many of us do, very much in my mind's eye. I have seen on the court's Twitter account and on the court's web pages different photographs of individuals in different locations following these proceedings. Can I just say that this office and myself pledge to do our best to work closer with the people of the Central African Republic, to develop deeper bonds with them and with the national authorities of the Central African Republic, the specialized court of the CAR, consistent with the principle of complementarity. I have said repeatedly in various fora that the forum of justice is not important. The principle of justice is. But, Your Honours, today, this chamber is the forum, and Your Honours are the judges. And we are confident that after considering all the evidence, you will decide to commit this case to trial. Your Honours, those complete my opening remarks, hopefully within the time limits. Thank you so much.
Thank you, Mr. Prosecutor, for your statements. On a general note, since this is, as you mentioned, your first time addressing a chamber in your position, capacity as prosecutor, we wish you and your colleagues success in the accomplishment of the court's mandate. Now, it's 11:01. I will adjourn the hearing for half an hour. 11:30 we will resume and we will continue with you, Madam Counsel for the Office of Public Counsel for Victims. So thank you very much and see you later. Thank you.
All rise, veuillez vous lever.